Hi everyone, my name is Luwei Yi and I'll be discussing the fundamental principles underlying the system of registered land. This system originally established by the Land Registration Act 1925 and was significantly updated by the Land Registration Act 2002. There are three core principles: the mirror principle, the curtain principle, and the insurance principle. I will focus especially on the mirror principle, explaining how it operates, and briefly explain the two other supporting principles to the context to which it remains effective in practice. Then I'll consider where the current legal framework will still meet the goal of efficiency, accessibility, and transparency, and also propose reforms to improve the system ahead. The mirror principle means that the land register should accurately reflect all interests in a plot of land. The inspection of the register should reveal the identity of the owner, the nature of his ownership, any limitations on his ownership, and any rights enjoyed by other person over the land that are adverse to the owner. If the register shows everything clearly, the purchaser then can confidently know what he is buying, and the person with an interest in the land knows that their rights are protected. However, interests in land continue to exist outside the register. If the rights can exist in land that cannot or not need to be registered, then the register does not give an accurate picture of the title to the land. The curtain principle is about the idea that a certain equitable interest in land should be hidden behind the curtain of a special type of trust. If the person wishes to buy a registered land that is subject held on trust, the purchaser needs to deal with the legal title of the land, which is held by the trustee and reflect on the title register. Any such of equitable rights will be overreached is because the proper formalities of the purchase are observed. These equitable rights will not affect the purchaser in his enjoyment of the land. However, although the interests of the equitable owners cannot affect the purchaser because of overreaching, those rights are not lost because of the process of overreaching. It operates to transfer the land itself to the money that the purchaser have just paid for. The trustee then hold the money in trust for the equitable owners. The insurance principle means that if a title is duly registered, it is guaranteed by the state. If any purchaser who suffers loss by reasons of the conclusive nature of the register, they can be compensated through a government-backed indemnity scheme. Any registration system that guarantees title effectively will need to provide a system of compensation for those persons who suffered loss by reason of the application of the system. A register of land titles, especially one that is designed to be absolute conclusive for most purpose, will always generate cases in which loss is caused to innocent parties simply because of the way that system works. Even though claims of compensation are rare, but in reality, the existence of the indemnity system is very important. It gives people confidence to rely on the register, knowing that if something does go wrong, they are protected by it. So, to sum up, the mirror principle discussed the idea that the register should reflect the totality of rights in and over the land, making it faster and easier to buy and sell. The mirror is not perfect because of the existence of the overriding interest, but over time it will become more accurate as more rights are registered. The curtain principle means that the equitable interest existing behind trust of land should be kept off the register and dealt with through the mechanism of overreaching. This has been largely achieved, although the cases in which overreaching does not apply. A purchaser might deal with those hidden rights. In the insurance principle talks about the idea that the state will guarantee the efficiency of the system by providing statutory compensation to the person suffering loss by reasons of the operation of the system. The merit principle is basically a good or beneficial concept that has been established in the registration system and brings key advantages in terms of increasing the accuracy, comprehensiveness, and reliability of the register for all concerned with dealings in land. However, the merit principle does not operate fully in the system of registered land in England and Wales. Even under the LRA 2002, it was never meant to. Some rights can affect the land and still bind a new owner or buyer, even though they are not recorded on the register. Under the LRA 2002, a buyer of the land is however bound by certain rights that are known as the overriding interests. Despite the fact that they are not listed on the register, this unregistered interest which overrides nevertheless contradicts the idea that the register should be a mirror of the legal status of the land. A common example is the rights of a person in actual occupation, such as a spouse or family member with a beneficial interest in the home. Even though these rights are invisible on the register, they are still enforceable against a buyer. This idea really goes against the mirror principle. If a right is not shown on the register but still has legal force, then the register cannot truly reflect reality. In the case of Williams and Glyn's Bank against Bolden, the House of Lords held that the bank which have lent money on the security of a house was bound by the interest of the owner's wife in the house and therefore was not entitled to vacant possession, which in sort to obtain for the purpose of enforcing the debt by sale. This weakens the buyer's confidence in the register and means due diligence must go beyond what is recorded, and that appears the crack in the mirror. The overriding status should be afforded to certain types of rights on the basis that it is unreasonable for the rights holder to register their interests. The Land Registration Act 2002 has been received with much criticism and rightly so. This act was brought into the modern age and was designed to reshape conveyancing in England and Wales. Conveyancing was established by LRA 1925. The land registration system underwent fundamental reforms under the LRA 2002, ending up rejecting key limitations and recommending a more modern framework. Despite the improvements introduced by the LRA 2002, the Act was criticized for retaining the doctrine of overriding interest. The provision concerning the overriding status of the rights of persons in actual occupations are centered to the attempt in the 2002 Act is diminish the range and scope of unregistered interests that might be bind a purchaser of land. These interests, especially to those on the actual occupation under Schedule 3, Paragraph 2 of the Land Registration Act 2002, mention that the rights of a person in actual occupation of land may bind a purchaser even if those rights do not appear on the register. This creates a direct conflict with the mirror principle because they are not recorded on the register but can still bind a buyer, which says that the register should be a complete and accurate reflection of the title. It introduced hidden legal risks and served as a warning to a prospective purchaser of the existence of reverse rights. In the case of Fairfield Limited and Wallside Limited, the claimant enjoyed a right extending to the entirety of the premises but was in actual occupation of only part. The Court of Appeal held that the right in the entirety was enforceable as an overriding interest. Therefore, the Act should be amended to narrow the list of overriding interests to be more transparent and reduce any hidden interests. It needs to be formally declared or registered during the sales process. This kind of reform could be an improvement of transparency and make the register more accurate reflection of ownership. The second reform is the full completion of e-conveyancing. E-conveyancing was introduced to propose a modern digital future of conveyancing. The LRA 2002 laid down the foundation of e-conveyancing, but is still not fully complemented. Traditional paper-based conveyancing remains slow, prone to delays, and vulnerable to human error and fraud. Many years have passed, and at the same time, the technology is also improving. The new technology compared with the e-conveyancing during the LRA 2002, whether electronic conveyancing will actually deliver all the anticipated benefits is uncertain, such as speed, transparency, security, and accessibility in practice. Therefore, a new system can come into operation. A more comprehensive e-conveyancing platform should be introduced. This makes a faster transaction and of course reduce delays and manual paperwork. More efficient on bringing the register a closer look of a more immediate and accurate reflection of ownership and interests. In conclusion, while the Land Registration Act 2002 aimed to modernize and simplify the land registration system through principles like the mirror, curtain, and insurance principle, the reality is more complex. The mirror principle falls short of its ideal due to the existence of overriding interests, fraud, and human error, which means that the register does not always reflect the full picture. Although curtain principle and overreaching mechanisms offer some protection, but they do not apply in all cases, whereby the insurance principle provides a safety net, but relying on compensation after harm has occurred in far from ideal. To build a truly efficient, transparent, and accessible system, reforms are needed to a more complete registration and strengthening protection against fraud, and fully implementing e-conveyancing. This ensures that the register better serves both legal certainty and public confidence moving forward. These are my references, and thank you for listening.